I'll call our first case today, Miller versus Department of Corrections. This is a 20-minute oral argument. You have 2 minutes of a free fire zone, which you may waive. And we ask that if you're going to reserve time, that you keep track of that yourself.
Thank you, Chief Justice. Good morning again, Your Honors. John Marco on behalf of the plaintiff appellants, Miller family, and Whitman, who are here today. Your Honors, this is a matter of first impression. The question posed is whether Michigan recognizes an associational retaliation claim, also called a third-party retaliation claim. On a C-8 motion, the trial court held that we had pled a viable claim based largely in part on the Thompson versus North American Stainless case, which is a unanimous Supreme Court opinion United States Supreme Court opinion by Justice Scalia, issued in 2011. The Court of Appeals reversed in a published opinion and held that Michigan does not recognize any associational retaliation claims, held that the exclusive avenue to pursue such a claim under Elliott Larson would be under subsection F, and basically dismissed the case, sent it back to the trial court. The Court of Appeals opinion is in conflict with the plain language of the Elliott Larson Civil Rights Act, which we discussed at length yesterday, the intent of the act, and precedential case law, specifically the Thompson versus North American Stainless framework, which sets forth a very reasonable, balanced framework that can be used when analyzing third-party retaliation cases. So I would ask this court to reverse the Court of Appeals, adopt the framework set forth by the United States Supreme Court in Thompson versus Stainless Steel. It's important to understand factually the loopholes that the Court of Appeals opinion has created in this case. So, for example, if a woman and her husband work at a company, and the CEO of the company sexually harasses or assaults the woman, and she reports it, under the Court of Appeals opinion in this case, the company could strike back by firing that woman's husband, and according to the Court of Appeals, that would be perfectly legal in Michigan. And that's not what the Elliott Larson Civil Rights Act says, and that wasn't what it's intended to do.
Let me just ask, isn't your claim that your clients participated honestly in an investigation, and that's why they've been retaliated against?
My claim, as the complaint has alleged, Justice Zara, in this particular case, Mr. Griffey filed a civil rights complaint internally on behalf of his wife. The Department of Corrections then terminated, as a result of that, Mr. Miller and Mr. Whitman, along with Mr. Griffey as well.
It had nothing to do with their participation in the investigation?
No, the civil rights, and that was one issue that was brought up by Judge Murray at the Court of Appeals. And to be clear, the investigation was not a civil rights investigation into Mr. Griffey. It was a separate investigation that they used as a vehicle to terminate his employment along with Mr. Whitman and Mr. Miller. He complained about his wife's harassment. His wife was called Mammy, asked if she wanted chitlins on her pizza, all kind of horrible things, said black people run for food, all kinds of stuff. And he reported that, and then shortly thereafter, within, I think, a matter of 6 months, he was terminated along with the other plaintiffs in this case.
I didn't look at this yesterday or the day before, but I thought in your complaint it actually said that they were terminated for participating honestly in an investigation.
They participated honestly in the investigation into Mr. Griffey, Justice Zara.
Okay, and are you alleging that's why they were terminated?
I'm alleging that they were terminated for being associated with the Griffeys who complained about protected civil rights activity. So it's the exact same thing as in the Thompson case. They were terminated for their association, for their relationship. And the Thompson looks at the relationship between the parties. So, for example, in the hypothetical I gave you about a woman complaining that the CEO sexually assaulted her or harassed her, the husband may not have reported it. He may not have been involved he may not have seen the sexual harassment. He may not have made a complaint on his own. And he's just literally a bystander, but he has an association to the aggrieved party. By virtue of that association, Justice Scalia, and this is a unanimous opinion.
No, look I'm not arguing the law with you. I'm trying to understand the facts and what you're pleading. You want to just go into my mind and try to figure what I'm trying to get to at the end, but it's quite simple. I'm asking you a question. Is it about their participation in the investigation? Yes or no?
It's about their association with the Griffeys.
So the participation in the investigation has nothing to do with the termination?
That's correct.
Okay.
It's their association. The investigation was not a civil rights investigation.
Does it matter?
For associational retaliation, it does, I think.
But I'm even looking at subsection A, a direct claim of retaliation. If they were terminated for participating honestly, wouldn't that be a direct claim under the Larson Civil Rights Act?
If it was a civil rights investigation. So for example, if the Department of Corrections was investigating these racial allegations involving Lisa Griffey, Mammy, chitlins on your pizza, those, and the Millers and Whitman said, yes, I saw it, this is what happened, the supervisor said this, that is not associational retaliation, Your Honor. That is a direct retaliation because they were involved directly in the civil rights investigation. Here, there was a separate investigation that had absolutely nothing to do with anything. The Lansing sent, Stephen Marshke, who was the head of the internal affairs, sent in an investigator to the facility who was his friend and who was friendly, and they immediately set up charges on the Miller, Whitman, and Mr. Griffey, and they terminated them.
So what was the investigation about?
It was called, there was a prisoner on a suicide plan, and this is all contained in the Griffey versus Michigan Department of Corrections opinion, which was, I cited in my brief, which was, it was Cameron, Schwartzel, and another judge, I don't recall.
The judges really don't matter to me, just tell me what it was about.
Yeah, so there was alleged violation of policy. It had nothing to do with my clients or Mr. Griffey. It had to do with a guy by the name of Mr. Schooley, who was a completely different person. Lansing changed the investigator, the specific internal affairs coordinator, switched the investigator, who then immediately wrote up my clients.
I understand your position here. Then, just out of curiosity, why is it in the complaint? Participating honestly in this investigation.
We have a lot of things in the
It's
complaint.
confusing me, that's all.
I apologize for
Curious
that.
why.
Just to clarify, so right, we have two things. We have the original investigation, which was not a civil rights claim.
That's correct, Your Honor.
Right, and then the allegation that they get terminated because of their association, and then
That's correct, Your
doesn't
Honor.
involve an investigation into a civil rights complaint.
That's correct, Your Honor. And the department did say that they participated dishonestly. That was the preface to terminate them. So when I drafted the complaint, I wanted to make clear that they participated honestly, which the jury agreed with in the Griffey case, and that was upheld on appeal. So that's a established matter of fact. I think this is very simple. I mean, if you look at Title VII, and you look at the Elliott Larson Civil Rights Act, and we went over this history yesterday. So in 1963, we had the Constitution, we had the Convention, there was a constitutional mandate to pass the civil rights legislation. 1 year later, the federal government passes Title VII, which is the counterpart to the Elliott Larson Civil Rights Act. And then in 1976, our legislature passes ELCRA. And if you look at it, we adopted Section A of Title VII almost verbatim, and then the Michigan legislature expanded the protections by adding an additional, over the years, 5 subsets of additional protected activity. So the Court of Appeals essentially said Michigan's ELCRA is more narrow and provides less protection than federal law, which makes absolutely no sense.
So can you help me get to, if we understand and agree with your construction that this is an associational claim under sub A, and you said it's virtually the same thing as Thompson, and SCOTUS has interpreted that. The difference being the relationship, right? There was a different relationship, husband and wife in Thompson, and a different relationship. These are friends of, or coworkers of Griffey, who was reporting it, of his wife. So can you tell me why that distinction doesn't, can you explain that distinction and why that relationship in this case is still sufficiently recognizable under even the Thompson reasoning, and perhaps it's a difference, just to throw it in there, of C8 versus C10. Like, is it enough to plead the relationship, and maybe upon factual development, you may not
Yes,
be
Your
able to
Honor, and
establish?
thank you. Let me address that. So first of all, if we look at Thompson and what Justice Scalia's opinion in that, he says that we decline, and this is on page 175, he said, quote, "We must also decline to identify a fixed class of relationships for which third-party reprisals are unlawful." In other words, he was saying, we are not going to say, okay, if you're like a second cousin, you count. If you're a wife, you count. But if you're a third cousin, you're out. And the reason being is they use a reasonable worker standard. It's very fact-specific. And that came from the Burlington case, which our courts adopted in White versus Department of Transportation, which the question is, it's like in negligence, a reasonable person. In the employment context, it's a reasonable worker. What would dissuade a reasonable worker from making a complaint of harassment or making a complaint? So what's reasonable? And part of what's reasonable is a totality of the circumstances, and it's very fact-specific. And so the Supreme Court said, we're not going to draw a fine line. We're going to let the courts sort this out through fact-specific inquiries. And then I've cited to you, on page 18 of my brief, I've cited to you federal courts who've expanded on this. And Callahan versus City of New Haven Board of Education, that's a Connecticut federal court case where they say that friends and family members would also be protected. They said, of course, if this were not the rule, then employers could easily penalize an employee's protected activity merely by striking back at friends and family members who might happen to work as well for the employer. So I think what we can learn from these cases and from the United States Supreme Court's reasonable framework is we don't need to fix a precise class of people. I think it's fact-specific. The courts are going to look at it and see if it would dissuade a reasonable worker in that particular case.
So are we deciding that in this particular case, that relationship is sufficient?
I think that it is sufficient in this particular case based on the pleadings on a C8 standard, which, remember, is very lenient. Would it be so clearly unenforceable as a matter of law? And you can adopt Justice Scalia's framework almost verbatim. I would encourage this court from Thompson because it's very reasonable. It takes a rational approach to it, and it adopts law that we already have in this forum. So I don't need.
But so to Justice Kavanaugh's point, let's assume we agree with you. We think Thompson is on point. Do we remand then for the court to figure out if your claim can survive?
I think that based on the facts pled on a C8, the trial court already did that. The trial court already analyzed this on a C8, and they used the framework from Thompson, finding this a matter of first impression in Michigan, and said based on that, on a C8, we're going to let discovery happen. At a C10, we haven't even started this case. I mean, at a C10 level, then we can make finer distinctions. We'll have a record about, was this just a colleague that he saw in the hall once in a while, or did the Department of Corrections know that this was a very tight, close-knit relationship that would dissuade a reasonable worker? But these are factual determinations that shouldn't be made at a C8 level, and so I think we have the framework here. We have the framework, it's been set out, and the Court of Appeals decision that the Elliott Larson's provides less protection flies in the face of everything we discussed yesterday in the plain language of the statute. Why in the world would the legislature take subsection A and then add an additional 5 sections? And the Elliott Larson Civil Rights Act is one of the strongest anti-discrimination statutes in the country. The New York Times just did an article on it about 4 months ago. We recognize protected classes that are not recognized anywhere else. Weight, for example, height, for example. And this goes in line with what we discussed about the intent of the framers from the 1963 Constitution, that this was supposed to be one of the strongest unalienable rights that we have. And if it's good enough for the Title VII, I certainly think that this is a simple question for this court, and the fine-tuning and contours of that can be done on a case-by-case basis and can be done later. But certainly, we're at a C8. We're at a C8 stage here. With regards to subsection F, so this court asked us to brief whether subsection F was the only way that someone could ever bring a claim. The Court of Appeals, in their published opinion, relied on, cited the Fair Housing Act as a basis for interpreting subsection F, which there's only 2 cases I could find that have ever cited subsection F of the Michigan Elliott Larson Civil Rights Act. They were both unpublished, and they did not deal with associational retaliation in any way. So I think there can be multiple paths. These subsections are complementary, so you can violate multiple. So for example, subsection C in the Elliott Larson Civil Rights Act, attempt directly or indirectly to commit an act prohibited by this act. I certainly think at a C8 stage, our complaint shows that the defendants attempted indirectly to violate the Elliott Larson Civil Rights Act by terminating individuals who are associated with an individual who made a complaint.
That's only if we agree with your principal argument that that's prohibited. Isn't that sort of a circular argument?
No, subsection C, Justice Viviano says, 2 or more persons shall not conspire, or a person shall not attempt directly or indirectly to commit an act prohibited by this act. That's pretty broad language. The legislature's use of the language indirectly.
So what's the act prohibited by this act that you're talking about if it's not your whole argument today that the associational claim is valid? What, it must be a different act prohibited by the act?
It would be dissuading a reasonable worker from
It goes
making,
back to your principal claim. So all I'm saying is if we don't agree with you on that point, then this doesn't add anything, does it?
I think it shows that it's more expansive than Title VII.
Well, it has more provisions, that's true, but our job is to try to interpret this language, which admittedly is sort of a hodgepodge, right? It's a difficult question of statutory interpretation here, and what the Court of Appeals said is trying to read subsection F along with subsection A, that subsection F applies more specifically to associational claims.
I
Agree
think,
with that, or do you not?
I do not agree that these sections are exclusive in any way. I think a violation of one can be a violation of all, and
That's not typically how we would read language, right? That one provision means the same as the other provision with different words, and that means the same as a third provision that has different words. Typically, when the legislature uses different words, we ascribe different meaning to those words, do we not?
Well, how would you square that with the words attempt directly or indirectly to commit an act prohibited by this act, which could,
You have me hopelessly confused there, because I've already asked you, what's the act prohibited by this act? If it's not your principal claim that you're here arguing we should recognize. If it's some other act prohibited by this act, then maybe that provision adds something or creates a different claim for your client. But if it's the same act that you're already, or a violation that you're already complaining of, I'm not sure how that adds anything.
well, I think we start with A.
You have
and
two different claims and you get two different damages remedies for the same?
Absolutely not. Absolutely, you don't get to, but we always have cases where we have a set of facts that rises to multiple claims. For example, you can have a premises claim and a negligence claim. You can have viable claims for both. You don't get double damages, but there's multiple pathways. These are complementary. It would render that language meaningless if it didn't have some import for the act. And attempt directly or indirectly to commit an act prohibited by this act.
Just so I'm clear, the act prohibited by the act that you're complaining of is this associational claim, right? This third-party
Correct.
retaliation claim.
Correct.
So it's the same claim.
It's the same claim. It's the same claim with multiple pathways that would prevent it from being dismissed on a C8 motion. There's nothing in there that says it's exclusive.
What do you think is prohibited by subsection F as it relates to a third-party claim?
Well, subsection F says coerce, intimidate, threaten, or interfere with a person in the exercise or enjoyment of. Then it has another clause. Then it says any right granted or protected by this act. And that is a right to be free from retaliation for protected civil rights activity, which is spelled out in the language and the intent of the statute. I have 45 seconds left. I'll save it for rebuttal. Thank you.
Chief Justice, and may it please the court, I'm Assistant Attorney General Ken Dow Asbenson, and I represent the the Michigan Department of Corrections in this case. With me at counsel's table is Deputy Solicitor General Eric Restucia. The Elliott Larson Civil Rights Act and Title VII are similar, but they are not identical. Two relevant textual differences between Title VII and ELCRA are first, the presence of Section 701F in ELCRA, which provides specific third-party language, any other person, and is not present in Title VII. The second difference is between the cause of action provisions in the two statutes. While Title VII extends a cause of action to the person claiming to be aggrieved, ELCRA only allows suit by a person alleging a violation of this act. And a violation of this act are the things spelled out in Sections 701A through F. These differences lead to the conclusion that ELCRA establishes a right to recover for third-party retaliation claims, but the basis for these claims is Section 701F. In practice, this means that a plaintiff can only bring a third-party claim under ELCRA for having aided or encouraged any other person in the exercise of a right protected by ELCRA. This is not the same third-party retaliation claim as is available under Title VII as interpreted by Thompson. But that's because the text of ELCRA is different and has evolved differently from Title VII. Under ELCRA, there is no recovery for mere close relationship. There must be action. And this solves the problem pointed out by Justice Scalia in the Thompson decision of line drawing problems. Under the Elliott Larson Civil Rights Act, you don't have the same line drawing problems that you do under Thompson. And
Help me understand this. So ELCRA has sub A, which is identical to the federal statute, interpreted under Thompson as providing for an associational claim.
they are largely similar.
Okay. So that's the case. That's what ELCRA protects. And then subsequently, we add F, or the legislature adds F. And in doing so, your position is that it stripped the associational claim, the availability of that, from A. Isn't that kind of a really indirect way to say that we don't recognize associational claims?
That's not my argument.
Okay.
My argument is that until 2011 with the Thompson case, there was no settled case law under Title VII permitting associational retaliation claims. In fact, the Thompson case at the Sixth Circuit went the other way. It was reversed by the Supreme Court. And so there has not been a specific associational retaliation claim in the law in 1992 when the legislature added subsection F. So at that time, there was no associational retaliation claim available. And so the legislature made a third-party retaliation claim available in 1992. Again, it was strengthening the ELCRA provision because there was no specific third-party claim. It was adding that third-party claim.
You
And so-
said it wasn't available, but it's not like, I mean, SCOTUS didn't create it, right? I mean, that statutory language was there.
That statutory language was there, but that would get to my second point.
Okay.
And that is that the cause of action provisions are different between Title VII and the Elliott Larson Civil Rights Act. And specifically, the differences are that under Title VII, you have to be someone who has, excuse me. Under Title VII, you have to be a person who is claiming to be aggrieved. But under ELCRA, it allows suit for persons alleging a violation of this act. And the violations of this act are what you're going to find in Section 701A through F. And so the difference is that under Title VII, it's the person who's claiming to be aggrieved has a cause of action. But under the Elliott Larson Civil Rights Act, it's only someone who is alleging a violation of this act. And again, those violations of the act are spelled out in Section 701A
So why
through
can't
F.
this case be resolved on that section, 28011, where it says that the person alleging a violation of this act may sue? plaintiffs have alleged a violation of 2701A by retaliating against Cedric. So how are they not persons
Because they,
alleging a violation?
because they have not alleged a violation as outlined in sections 701A through F. The only violation that they have alleged is this associational retaliation, and the text of A in and of itself doesn't actually support that. If we look at the actual words that are used in the text of A, subsection A provides that one or more persons may not retaliate or discriminate against a person because the person has, and then it lists 8 protected activities. None of those things provide for an associational retaliation. If we actually dig into the language of A, it doesn't provide an actual associational retaliation. It says retaliate or discriminate against a person because the person has opposed a violation, made a charge, filed a complaint, testified, assisted, participated in an investigation.
Why
participated-
can't you have, let's say that I employ both Justice Viviano and Chief Justice Clement, and Justice Viviano has engaged in some kind of activity protected under the Act, and I really don't like him, and I know that, well, I can't really go directly after him, but I know that he really likes Chief Justice Clement, and so I'm going to retaliate against Justice Viviano by firing Chief Justice Clement.
Not very nice.
It's not, and I wouldn't do it. I'm just saying, isn't that, I am retaliating. Now, Justice Viviano may not have damages, right? But Justice Clement, and would have to figure out whether or not she has a remedy as well, right? I'm retaliating against Justice Viviano, who is a person who has made a charge, filed a complaint, testified, blah, 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 under the Act. I'm retaliating against him by firing Chief Justice Clement. It's really putting him in a jam. He really likes her. Now he has to do all the work that Justice Clement used to do for him, let's say.
Well, and with that hypothetical, I'll assume that Justice Viviano engaged in some kind of protected activity
Correct.
himself.
Yes.
And if Justice Clement did not aid or encourage Justice Viviano, then she would not have a claim under the Elliott-Larsen Civil Rights Act.
So, I mean, I'm just trying to wrap my head around this. What if there's like email evidence? We should fire Justice Clement because that way we can really get back at Justice Viviano. That's totally fine. That's not retaliation?
Unless the standard
The
under
answer is
the
no.
Elliott-Larsen Civil Rights Act is that you have to engage in some kind of activity. I think the bar of aiding or encouraging someone else is very low. I think we have to start with the position that Justice Viviano filed some kind of complaint or engaged in some kind of protected activity. And I think in the case, the hypothetical provided by plaintiff's counsel, a husband or a wife is going to be aiding or encouraging their spouse.
Well, but that's not what
That-
Thompson said. Didn't Thompson say, basically, I'm firing the wife engaged in protected conduct. I'm not taking an action against her. I'm firing the husband.
Correct.
And Thompson said that's a violation of basically our sub A.
Correct. But it read it in through the cause of action provision. You don't get that without the expanded language in Title VII's cause of action provision, which specifically applies to a person who's aggrieved. That person has been aggrieved. There's no aggrievable language in ELCRA. And so that spouse is aggrieved by some violation of the act. Whereas, under Elliott-Larsen Civil Rights Act, you have to claim that there's been a violation of the act, and those are set out, as Justice Viviano pointed out, in specific subparts of the act.
I mean, it really comes down to how we define retaliation, how broad it is, right? Your state has to only be retaliate. The only way you can retaliate is if the person who filed the claim or made the civil rights complaint is the one who suffers an adverse job action. Obviously, Justice Kavanaugh gave an example where retaliation against the person can be sort of indirect. So that's the debate, right? How far can retaliation go?
I think that is the debate, but we're bound by the actual language in this statute. Subsection F uses specific third-party language. The legislature could have used that any other person language in subsection A, but it chose not to. It included that only in subsection F. And so the language of subsection F is specific. If A provides for some kind of third-party associational retaliation, there's no point to having subsection F.
Let's just focus on that for a minute. I think that's basically the point of the Court of Appeals opinion, that subsection, under the Thompson interpretation of retaliate, which, has some analytical force, that would render F or fully subsume subsection F. There would literally be no reason that anyone would ever bring a claim under F, because you have a higher bar of having to show that you aided or encouraged. While that wouldn't be necessary under A. Is that the nub of the problem, that F would be rendered nugatory or completely subsumed under that interpretation of A?
Absolutely. If Thompson is adopted and applies to A, then subsection F is nugatory. There is no point for it. And the point for this, subsection F, was actually to expand ELCRA in 1992 when it wasn't clear that there was any kind of third-party claim. So again, the legislature was strengthening.
What do you say to counsel's point that has some rhetorical force, that it's pretty ironic or perplexing that in an effort to obviously expand the scope of this section by adding these provisions, that the legislature actually eliminated some conduct that otherwise would be covered by the provision?
Right, and I think that the importance of that is that Scalia himself, in the Thompson opinion, points out one of the weaknesses of the Thompson opinion, and it's the line drawing. What's the difference between someone who's just an acquaintance who gets a slap on the wrist at work versus a spouse who's fired? Obviously, Justice Scalia says the spouse who's fired is under Thompson and under Title VII is always going to lead to a retaliation claim. There's no issue with that line drawing under the Elliott-Larsen Civil Rights Act when there is a subsection F. There's a bright line rule. And so where Thompson has a big gray area. You struggle to draw lines under a Thompson opinion. You don't under subsection F. And so it provides clarity. It provides both a third-party retaliation claim, and it also provides clarity. And it doesn't leave Michigan residents without recourse. They can still file a Title VII claim for associational retaliation. It's not like they're going to be left high and dry. They have that same claim.
But they would
under
have to
Title
show
VII.
that they've aided or encouraged another person in the exercise of their rights.
Not to bring a Title VII claim, but to bring an ELCRA claim, yes.
For ELCRA, sorry, yes. So I'm sort of, is it that we assume all friends probably aided and encouraged their friend with their claim? I'm wondering, I think it's a safe bet in most circumstances. Do it, I'm there for you. But I'm guessing then we would get into a knowledge of what the employer knew about aiding and encouraging, correct?
I think so. But I think in most cases, it's going to be there. In this case, it is not here, and it's been admitted, I believe it was on page 14 of the plaintiff's brief, 12 or 14 of the plaintiff's brief, that there was no aiding or encouraging. The plaintiffs in this particular case sat on their hands and did absolutely nothing. They did not aid or encourage their friends. They've admitted they haven't aided or encouraged their friends.
But doesn't that, Justice Viviano asked about rendering F nugatory if we interpret A broadly. Doesn't that make the point? There are two pathways in these cases. Some they've aided and encouraged, and in others they're just fired because they're the friend. Aren't those two different things?
But again, the actual language of A doesn't support that argument. The text found in A, it talks about the person who has engaged in these activities being the one who has a claim under subsection A. It lists 8 specific protected activities that a person can engage in, and if that person's retaliated against, then they have a claim.
All the work there is in the word retaliate, right? If it's interpreted broadly as it is in Thompson, then that's how that claim is created here. But I guess to continue the interpretive discussion, I think the answer to the question of how it could have, how the legislature, we could end up with something different than maybe they expected the statute to be applied, is that we're not interested or supposed to be focused on expected applications. We're supposed to be looking at what the plain language is, because that's what the public is left with when they pull out the statute books. And doesn't it come down to, in this case, and it's what makes it such a difficult case, a question of how hard should we work to harmonize these two provisions? Isn't that the question here? Should we work so hard, you're suggesting, that we would not give the word retaliate in A, the interpretation that the U.S. Supreme Court has given it, and instead focus the third-party retaliation claims under subsection F? Or on the other hand, should we treat the statute as sort of a belt and suspenders approach, where maybe there is some overlap, but we assume that's what the legislature intended? How do we know how far to go in harmonizing these statutes, or these subsections?
Well, I think here there are differences in the text, and so I think this court has to wrestle with what those differences are. Specifically, there is the difference of the existence of subsection F.
But there's no real differences in A, right? So you're asking us to interpret A differently than similar language has been interpreted by the U.S. Supreme Court, right?
I will note first that the word retaliate does not appear in Title VII. The word retaliate does appear in the Elliott-Larsen Civil Rights Act, sub A. So there are differences. I would also note the specific language, a person and the person. I think that is very specific language implying that the person has to engage in those protected activities to have a claim. But then I'll also note, Thompson gets into a whole discussion on standing. And the reason for that is because subsection A is interpreted in light of the cause of action provision. It's not just that Thompson interprets subsection A in a vacuum. It doesn't do that. It reads in through the cause of action provision, which specifically says, a person claiming to be aggrieved who's anyone who could have damage. And so through that claims to be aggrieved language is how you read that associational discrimination into sub A. It's not that Thompson just looks at sub A in a vacuum and says, this provides third-party retaliation. It doesn't do that. It only does that reading it in through the cause of action provision, which is different than the
So
Elliott-Larsen
tell me
Civil
why
Rights
that
Act.
difference in the cause of action provision makes a difference. And again, not to beat this horrible analogy to death, but if Justice Clement brings under 2801, she's a person alleging a violation that I fired her in retaliation for Justice Viviano's protected conduct. So she's a person alleging a violation of this act, may bring a civil action for damages, and that means damages for injury or loss caused by the violation. So why can't her damages, her loss of job, be, why does that cause of action provision, and I get that you're saying it's different than saying aggrieved, we don't have that language. Why does that difference why does it make a difference? Because I'm still struggling with that.
Because Justice Clement would have to be alleging a violation of the act. And what is the violation of the act that Justice Clement would be alleging there?
She says I retaliated against Justice Viviano
Right?
by firing her.
But you
That's
did,
a violation of the act that she is bringing because she suffered damages as a result of me doing that.
but that's not a violation as to Justice Clement.
It
Doesn't say that, though.
It doesn't say that.
It does when you read the articles in subsection A. It says
Retaliate against a person.
a person because the person. That's referring
I am.
back to a person.
I'm retaliating against him because he filed a claim, because he has engaged in protective conduct. How I'm doing that is firing her.
But
So
there's
I am retaliating against Justice Viviano. That's a violation of the act. Justice Clement suffered damages as a result of that act. And 2801, 1 and 3 allow her to bring that claim.
but she doesn't have a violation of the act.
Correct.
Because there's no language in subsection A that talks about any other person. So if another person is harmed, there would need to be that language in subsection A talking about any other person. Justice Clement would be the any other person.
Why isn't that clear in 801-1? It just says a person alleging a violation of this act.
A person alleging a violation of this act.
Want
And
us to
you s-
read back to 701A?
And so you have to find that actual violation of the act. And in this particular case, there's no specific violation of the Elliott Larson Civil Rights Act, subs A through F, that has actually been alleged in the complaint.
They allege in their complaint a violation of 701A.
They allege a violation of 701A, but they didn't engage in the protected activity that's listed in 701A. And the articles A and the make it clear that 701A only applies to the person who's engaged in the protected activity. And that's how this court interpreted specifically subsection A in the Garg case, when it said that the first prong of a retaliation claim is that someone has to engage in a protected activity. Plaintiff is asking for an expanded interpretation of that act, but this court's already ruled in the Garg case that there has to be a protected activity if you're suing under subsection A. And there was no protected activity that the plaintiffs in this case engaged in. I see that my time has expired. Thank you.
Honors, look at the actual language and text, as Justice Viviano pointed out. The Elliott Larson Civil Rights Act uses retaliate or discriminate in subsection A. Title VII doesn't even use the word retaliate, it only uses the word discriminate. Clearly, they drafted the Elliott Larson Civil Rights Act. It's broader in its reading than Title VII, and it's clear by the text. And Justice Scalia engaged in a textual analysis in Thompson based on a more limited statute and found that it protected the exact same type of protection I'm asking for here. And we can't lose sight of the intent. This is a remedial statute, Elliott Larson Civil Rights Act. It's supposed to be read in a way to effectuate its purpose, which is to eradicate discrimination. We can't lose sight of that the legislature would have a loophole that you could fire friends or loved ones as a way to get back at people who engage in protected activity. Thank you, Your Honors.
Thank you both. The case will be submitted.